Our next panel is on the subject of legislation and statutory interpretation. As most of you know, Phil, along with Bill Eskridge, has been one of the leading figures in this field. In fact, I think more than that, I think that through the casebook and his other writing, Phil has done a lot to create the topic of statutory interpretation as a field of scholarship. The first edition of their casebook really reconceptualized the issues, building on some work by predecessors, but really bringing it into a much more modern context. There was a review of the book by Judge Richard Posner at the time that said that this was one of the rare books that's not only an excellent set of teaching materials, but that in fact essentially creates a field of law by offering a vision of what makes that field important and distinctive. And since that time, there has been a real explosion of interest among both scholars and judges and lawyers in the question of how to approach the interpretation of statutes. Much of the debate has been about what a layperson might regard as a fairly small technical issue, which is whether it's appropriate for judges to consider legislative history, to consider the debates within Congress when interpreting a statute. But this is really only the tip of the iceberg in terms of a much broader set of disagreements about the whole enterprise of statutory interpretation, about what we should be trying to accomplish when interpreting a statute and what factors and methods are legitimate for a court or a member of the executive branch to use. As the casebook pointed out, as a practical matter, the great bulk of our modern legal system is statutory. Yes, there are important and high-profile constitutional issues. Yes, there are still some areas of the law, like torts, where the common law looms large. But when you think about criminal law, you think about environmental law, you think about civil rights law, and so on and so on and so on, those are all statutory. And the question of how courts are going to interpret and apply those statutes has probably greater practical importance than how they interpret the Constitution. We have a very distinguished group of speakers on this panel, and I'm just going to briefly run down the list so that I don't use up our scarce time for introductions. But before I do that, I have a couple of housekeeping notes that I wanted to share. The first is to hold on to your name tag. On the back of the name tag is the number of your table at dinner if you're staying for the dinner. So you need that in order, otherwise you're going to have to wander around the room trying to figure out where to sit. So hold on to those name tags. Also, when this panel is over, we'll be having lunch next door. So what you need to do is exit the building, turn right, and come back into the building next to it. And I guess panelists, if people start getting up en masse and walking out of the room, it probably means we've run out of time. Our first speaker will be James Brudney, who has the Baker Chair in Law at Ohio State University, and besides his writings on statutory interpretation, is also a prominent scholar of labor and employment law. James Emmett, who is an Australian barrister, who got to know Phil when Phil was in Australia discussing statutory interpretation. Our third panelist is John Manning, who is the Bromley professor at Harvard Law School. John is perhaps the leading academic advocate of textualism. And while neither Phil nor I, for that matter, are textualists, if we were going to be textualists, we would want to be John Manning. And then last but far from least is Peter Strauss, who is one of the towering figures in administrative law scholarship, and which inevitably involves statutory interpretation and legislation issues, because virtually everything administrative agencies do stems from some statutory authority. So let me turn over the microphone first to Jim Brudney. Thank you.
I couldn't help but think on the if I were a textualist back to a bar course prep I took too many decades ago, where it said, since none of us knew anything about commercial law, that the answer to every question on the bar exam had to be, this doesn't sound like a holder in due course, but if I were a holder in due course. I want to thank Dan Farber, the editors of California Law Review, and the staff and faculty here at Berkeley who have put together this symposium. And like many others, I benefited greatly from being mentored into the academy by Phil, and even more from having him as a model of reasoned thinking about statutory interpretation. My paper addresses an issue on which the first panel, as the first panel observed, Phil has written extensively and insightfully the role of the canons in construing statutes. I guess after the first panel, though, I feel a little bit like Melville's phrase of lowering the conceit of attainable felicity here. What I draw from Phil's treatment of the canons are two general themes. The first is an effort to unmask, to critically examine the canons and the claims that the canons promote more predictable construction of statutes and that they foster more neutral policy outcomes. The second theme is Phil's effort to understand and to justify how he views the canons as performing a useful institutional function in particular settings. Phil ultimately defends the canons' institutional role, but in more reserved terms than those offered by canon enthusiasts. So a part of my paper focuses on Phil's approach to the canons, but another part builds on the reservations that he's expressed by raising two institutional concerns of my own about how the canons differ from interpretive resources generated by Congress and the executive branch, although I think Phil might well agree with them. I suggest that when considered in comparative perspective, the canons are missing an important historically or pragmatically grounded legitimacy, and that they also lack a critical element of objectivity. So let me start with Phil's characteristically nuanced approach of both the unmasking and the defending. With respect to the claim that the language canons in particular enhance predictability, Phil is unpersuaded. In his succinct essay entitled Faithful Interpretation, he contends that the concept of ordinary or conventional meaning rest on the dubious assumption that statutes are, or largely can be, self-defining. He observes that statutes are much more than intricate linguistic puzzles, and I will say that many of Phil's insights and analyses may seem mainstream today. They were not mainstream when he first made them, as he has been making them for 20 years. They are more than intricate linguistic puzzles, he wrote. They're instruments of practical contextual communication, and they're instruments of social governance. And because the legal interpretive community's attribution of meaning to a statute is going to be both complex and normatively driven, it's neither candid nor constructive to assert that legal interpretation relies in any conclusive or mechanical way on notions of conventional usage or ordinary meaning. With respect to the claim that the substantive canons promote neutrality, Phil is, if anything, even more skeptical. A principal concern stems from the court's tendency to create new substantive canons. In theory, a judicially expressed policy preference does not become a canon until it's firmly rooted and widely recognized. But the sheer volume of substantive canons relied on by the court in recent times has raised questions as to whether these are stable and judicially entrenched norms. And of the more than 100 substantive policy canons invoked by the Rehnquist Court and chronicled by Phil in the casebook, many, if not most, narrow the scope or impact of congressional text by assigning broader authority and discretion to the states, to the executive branch, and to the laws of other nations. And as Phil also observes, the Court may announce a new policy presumption and shortly thereafter reference that presumption as an established substantive canon based simply on its prior decision. Phil also points to dramatic shifts in canon meaning that have given rise to additional concerns about neutrality. When the Court suddenly elevates a relatively weak canon into a clear statement rule, it effectively penalizes Congress for having failed to foresee years earlier how the Court's preferences were likely to evolve. This kind of bait-and-switch tactic enables the Court to disrespect Congress's prior policy judgments without acknowledging that it's doing so. Now, although Phil devotes considerable attention to unmasking claims advanced by canon proponents, he does regard the canons as performing useful functions in a court-created interpretive regime, and his defense addresses the language canon's role in encouraging more efficient statutory drafting and the substantive canon's role in signaling the intensity of judicial policy preferences. In each instance, his more modest justification invokes the Court's institutional function relative to Congress. At the same time, Phil is expressing reservations as to whether these institutional functions can ultimately be justified or how far they can be. So he doubts, for instance, whether the language canons really can make drafting more efficient, given that Congress doesn't care too much about the so-called rules of the road, and the courts tend to disagree about how they operate anyway. With respect to the substantive canons, Phil wonderfully recounts, as we have already heard, three separate instances of how the Court has used them as signaling devices, reflecting the Rehnquist Court's concern about persistent efforts to federalize various crimes, the Warren Court's concerns to address the rights of individual dissenters in a national security setting, and an ongoing concern to preserve structures of Indian sovereignty within our system of government. One might try to justify all three instances of signaling in terms of the Court favoring the politically powerless, and Professor Elhaug advances a version of this argument in his recent book. Phil's more inclined to view each of these efforts as intended to protect substantive values, not individuals or groups. But he is also worried about dishonoring Congress, a concern that would seem to apply regardless of whether the Court believes it's vindicating powerless groups or under-enforced norms. Now, the fact that we would applaud the Court for some institutionally based canon uses and condemn it for others is not per se troubling. We presumably would have the same range of reactions to interpretive understandings or preferences expressed by Congress and the executive branch. But once we view the canons as an institutional resource effectively promoting the Court's own preferences, certain first-order questions arise, questions I want to address for the rest of my time. Since the 1980s, judges and scholars have increasingly debated the comparative merits of what I guess I would call branch-specific interpretive assets, and especially the merits of the canons in legislative history. In terms of legitimacy, textualists have contended, none more elegantly than John, that legislative history may be suspect in constitutional terms, and they've at least implied that the canons as freestanding policy or language maxims steeped in custom or practice have a law-like respectability that is missing from legislative record documents that are opportunistically created in a partisan environment. In terms of reliability, legal process scholars have trumpeted the canons as off-the-rack gap-filling principles that enhance the clarity of enacted text. Again, this contrasts with politically messy legislative history susceptible to manipulation by judges. I believe the interpretive assets of all three branches play important roles in helping courts resolve particular disputes, and I've recently, in fact, written about the need to avoid a sort of one-size-fits-all approach to any of these assets. It turns out that the court uses canons and legislative history in intriguingly different ways in its statutory tax decisions compared with its statutory workplace decisions. And Justice Ginsburg's statutory interpretation jurisprudence reflects that, unlike some of her more dogmatic brethren, she's crafted a pretty eclectic approach to these assets, promoting a conversation with Congress that is at times rather muscular and at other times quite deferential. Nonetheless, I think it is worthwhile to examine the canons, as Phil has done, as an institutional resource. And to that end, I argue in the paper that the canons are normatively problematic when compared to legislative history and agency guidance from the standpoint of both legitimacy and objective reliability. And I want to offer these arguments as part of an effort to shift the conversation from where it has often been focused since the early 1990s. First, involving legitimacy. My argument stems from a sort of standard separation of powers understanding that in the statutory domain, federal courts are expected to act as agents of the politically accountable branches. The Constitution, in Article 1, authorizes Congress to organize itself in fulfillment of its legislative mission and requires Congress to publish a record of its legislative proceedings. Although the founders did not anticipate judicial review of statutes as that process has developed, their Article 1 contribution helped create two notable innovations in legislative design that arguably bear on how courts should approach their task. One new design feature derived from the Constitution's stance in the Journals Clause is to favor publication and disfavor secrecy. The English Parliament had operated in secrecy and even punished attempts to publish records of its proceedings. The Continental Congress had initially closed its proceedings to outsiders. The Constitutional Convention did so for the entire deliberative process. Contrary design approaches were certainly emerging at the time of the Constitution, but the development of published legislative proceedings was an innovation based on a belief that transparency would enlighten the public about the reasons and motives underlying their representatives' actions and thereby promote members' responsibilities to their constituents. A second legislative design innovation dating from the earliest Congress was the creation of permanent standing committees. Between 1789 and 1820, both the House and Senate shifted from a framework of temporary committees that responded to directives established by the larger body to a structure of permanent standing committees that shaped the priorities and agenda of the larger body. This permanent standing committee approach involves bills, as we know, being referred to a specialized subject matter group where they are reviewed in depth and recommended for consideration before the full chamber has addressed them. It's very different from the committee structure in the British Parliament, which to this day relies on standing committees that lack permanent subject matter jurisdiction, that are without continuing membership, and that can consider a bill in detail only after a vote approving the measure in full principle by the House. So since 1820, Congress has expanded its record-keeping requirements as it's developed more detailed procedures for how bills are introduced, discussed, modified, and approved. And by the middle of the 19th century, both the House and Senate had adopted resolutions calling for verbatim publication of floor proceedings, with legislators receiving copies of these published debates. Likewise, publication of and member access to standing committee reports dates from the early and mid-1800s. The publication requirements that are specified in Article 1 arose initially to keep the public informed. But by the 1850s, Congress had ordered daily publication and delivery of full chamber proceedings to all members to help keep legislators themselves informed. And distribution of committee reports to members also had become a common practice. So this evolution in the role of legislative record documents, I think, is relevant to the judicial role as well. Just as the founders wanted the public to have a record so they could understand what their agents are doing or have done, so members from the early 19th century have wanted access to information from their standing committees and from floor discussions. Member appreciation for the role of the legislative record in helping them to understand the meaning of text, including the deals and bargaining that are a key feature of American lawmaking, remains robust to this day. And the federal courts charged with resolving disputes about the meaning of often complex regulatory compromises have a historically grounded justification to examine this same record for parallel reasons. I don't mean to suggest the constitutional grounding automatically warrants legislative history reliance. There remain ample circumstances in which that narrative record is either vague, silent, or suspect. And certainly there are other instances where different resources have superior probative value. But the presence of this historic and functionally linked foundation confers an element of authoritative legitimacy. And the canons lack any comparable constitutional imprimatur. Their contribution and indeed their existence were not anticipated as part of the structure of federal lawmaking. And that constitutional silence is reinforced by the pragmatic perspective of legislators and their staffs. The available evidence suggests that unlike legislative history and executive branch directives, the canons are largely unknown to or ignored by legislators and staff who draft, negotiate, and vote on text. This lack of reliance makes sense from an institutional perspective because legislators and staff draft as part of an effort to create agreement out of the disagreement that Robert Post notes is constitutive of the political process. Their goal is agreement that's sufficient to secure enactment, not with a primary focus on grammatical or lexicographic clarity. Because the canon's interpretive relevance is fundamentally disconnected from the legislative process as a matter of both principle and practice, there's reason to question whether courts should value canons to the same extent as interpretive resources generated by Congress. It might still be plausible for canons to be valued over other assets as objective mechanisms for resolving disputes about meaning, if indeed they are. But it turns out canons are inferior to legislative history and agency guidance as well from the standpoint of objectivity. And so my second institutional observation, which is shorter, involves objective reliability. Because the consequences of statutory interpretation are direct and substantial in shaping human conduct, we expect this interpretation to be reliable, to be based on factors like rules or standards that lend themselves to a more objective than subjective application. And in this regard, the court's interpretive rubric has given rise to a relatively objective internal hierarchy for contextual resources produced by both Congress and the executive branch, a hierarchy recognized by Phil, by other scholars, and also by federal judges. Importantly, the priorities that are established for legislative history and agency guidance flow from how Congress and the executive function, both in terms of relying on authoritative sources of expertise and valuing deliberative processes. By contrast, there is no recognized authority or hierarchy of authority within the canonical universe. The court has never developed rules for harmonizing or prioritizing among the scores of canons that exist, many of which the court has created only recently. And that lack of an intelligible framework for ordering the canons renders them distinctly more susceptible to willful judging than other interpretive resources. Again, my position is not that the canons are incapable of situationally valuable application. They surely are. But the absence of this framework for ordering the canons means that judges invoking them inevitably have more subjective license than judges who regularly rely on legislative history or agency guidance. And the canonical approach is therefore placing, as Professor Merrill said at one point, a sort of subtle premium on judicial ingenuity. And it's in real tension with an attitude of deference toward both the legislative and the executive branches. And I think we should worry about that subjective license and the untethered and creative role that are played by the canons should be interstitial in comparison to the role of more anchored interpretive assets. Thanks.
Thanks. Sorry. At my early stage in my career, I'm very much a practitioner first and an academic second. I'm correspondingly honoured by the illustrious company in which I find myself and thrilled to have an opportunity to pay my respects to Phil here today. Notwithstanding my view of myself as a practitioner primarily, I'm keenly conscious of the importance of the academy as part of the legal system. And what I want to do with this paper is to note an Australian example from the field of statutory interpretation of the value of the academy to the administration of justice. The example lies in the atheoretical pragmatism that Phil has, I've broken something, noted among most judges in the US, and which exists among most judges in Australia. That pragmatism has been around for a very long time. What I think has happened recently in the last couple of decades is that it has become principled and almost even reliable in its application. In Australia, that starts in the early 80s with the introduction of a couple of provisions to the interpretation acts in most, or in fact in all Australian states and in the Commonwealth, which is our federal government. They all have a provision expressly providing that the court is to prefer a construction that promotes the purpose of the statute to a construction that does not promote that purpose. And they also all have a provision expressly authorising the court to have regard to extrinsic materials, including legislative history, in deciding, or in either confirming the ordinary meaning as the statutes put it, or determining the meaning where the provision is ambiguous or obscure or leads to a manifestly unreasonable result. In the 1990s, there were 3 decisions of the High Court that mapped out the role of legislative history in light of these new provisions. I won't bore you with the details of the case, but their names are Mills and Meeking, CIC Insurance and Bankstown Football Club, and Newcastle City Council and GIO General. As a result of those decisions, a few fairly straightforward propositions have emerged. That is, that context is always relevant, that it's relevant in the first instance and not merely when ambiguity arises, that context is used in its widest sense. It includes the pre-existing state of the law, the purpose of the statute and the legislative history, and that the purpose of the statute may be discerned in part from aspects of the legislative history. While the High Court has said that we will always have regard to legislative history, it still very rarely has a very powerful impact on the outcome. The words used in legislative history have none of the constitutional significance of the text adopted by Parliament. None of these propositions, I imagine, are particularly remarkable or controversial. At least they're not in Australia. In 1998, a single majority of the High Court delivered judgment in a case called Project Blue Sky and Australian Broadcasting Authority. A single judgment of the High Court of Australia has a particular significance that the US Supreme Court, that it wouldn't necessarily have in the US, in that the court doesn't, as a matter of course, write a single leading judgment to which a majority of judges subscribe their name. It's not uncommon to have a series of judgments in the majority, all of which reach the same outcome but by slightly different reasoning. What that means is that when you have a single majority judgment in Australia, it has a special privileged position, and you can say with reasonable confidence that a majority of the High Court that sat subscribed to the reasoning there and not merely the outcome. The Project Blue Sky case itself is about whether certain standards issued by the Australian Broadcasting Authority complied with the Broadcasting Act, and if they didn't, what the consequences of that non-compliance was. The actual outcome of the case is very important to administrative law practitioners and academics in Australia, but I won't go into it here. The point for present purposes is that it's regarded as the case where the High Court unambiguously embraced purposivism as the proper approach to statutory interpretation in Australia. And in a very qualified sense, that's what it did. The handful of the paragraphs where the majority talk about the proper approach to statutory interpretation in Australia read very much like a short summary of aspects of Hart and Sachs' purposivism. They say that the court repeats the observation already made that it's impossible to divorce text from context. It's always necessary to have regard to the purpose or policy of a provision. It's always necessary to read a statute as a whole. The court should approach legislation on the prima facie basis that its provisions are intended to give effect to harmonious goals. In determining the legal meaning of a text, you need to have regard to the context of the words, the consequences of available constructions, the purpose of the statute, and the canons of construction. And a conclusion about interpretation often involves a contestable judgment. Various factors have proved to be decisive in different contexts, but you can't even rank the factors. Different considerations will have different weight in different contexts. It's still the case that everybody takes to court whenever you expect some sort of argument about the approach to statutory interpretation or any real argument about how a statute works. After that, there was a series of cases, all in the last 10 years, all involving a single majority of the court, that have carefully qualified or limited the role of statutory purpose in Australia. I won't go into all of them today. One of the more interesting is a case called Peugeot Holdings and Gowans. That case involved legislation imposing fairly strict regulation on people who lend money on the security of pawned goods. The statute referred all the way through to pawns and pledges and pawned goods or pledged goods. Peugeot Holdings set up a business that looked and felt a lot like a pawnbroker. It lent money on the security of goods that it took into its possession and held. As a matter of strict legal form, though, it lent money on the security of a chattel mortgage, title passed. The majority of the High Court held, after careful consideration of a lot of aspects of the statute, that the statute simply didn't apply to chattel mortgages. There's a distinction that's been around since Roman law and has continued through the common law between three types of security: mortgages, pledges and other hypothecations. In the first, security lies in the passing of the title. In the second, security lies in the passing of the possession. And in the third, security is provided despite neither property nor title nor possession passing, because the creditor has a power of sale or a power of forfeiture. Justice Kirby wrote a very strongly worded dissent in that case, warning against a return to what he described as the dark days of literalism. In Justice Kirby's view, the decision of the majority frustrated the purpose of the statute, which in his view, in his honour's view, was to regulate the provision of credit on the security of chattels, while in Justice Kirby's view the words pawn and pledge have a technical legal meaning. They also have an ordinary meaning, that is leaving goods and borrowing money on off the back of them, and Justice Kirby thought that this ordinary meaning should be preferred. The slightly interesting point in my context now about the case is that the majority insisted all the way along that they were following the legislative mandate to prefer purpose. Their point was simply that there was nothing in the legislative history or the context to indicate that the purpose was as broad as Justice Kirby thought it was. In that, they were strongly influenced not only by the legislative adoption of the technical word, but also by the fact that the Pawnbrokers Act was part of a suite of legislation governing the provision of credit. Although the Pawnbrokers Act may not apply to chattel mortgages, a number of other legislation would. There's no reason to assume that the Pawnbrokers Act was meant to do everything. The point I want to make is that, with the greatest respect to Justice Kirby, I don't think this represents anything like a return to the dark days of literalism. The dispute between Justice Kirby and the majority is not about the proper approach to construing an act, nor about the role of purpose, nor even about the role of legislative history. The dispute is because, on balance, Justice Kirby took a different view of the purpose and the policy behind the act, and a different view of how that had made itself into the words. That's a matter of judgment on which reasonable minds may be expected to differ, and that's a point that your Felix Frankfurter made 60 years ago. After having regard to all relevant considerations, there will always be an irreducible act of judgment. There are slightly more mundane points of doctrine that, in my view, did separate the majority and Justice Kirby in that and other cases, but they're quite particular differences about the weight given to certain factors rather than general differences in approach. If there's time, I'll come back to them. In Australia at the moment, in my view, there's simply not the strong theoretical dispute in the judiciary about the role of purpose or the role of legislative history. Justice Kirby also accepts the straightforward observation that sometimes the purpose can be taken no further than the text chosen by Parliament. A striking example of that is the High Court's decision in a case called Stevens and Kabushiki Kaisha Sony Computer Entertainment. That was a case dealing with whether or not a particular electronic device was a technological protection measure as defined. It's a fiddly and complicated act. It's a fiddly and complicated definition. Without going into the details, each of the judges, including Justice Kirby, noted that the definition was plainly the result of legislative compromise between powerful competing groups. It didn't go as far as either the copyright users or the copyright owners wished, and it simply wasn't helpful to consider the purpose or policy in any way other than by reference to the words chosen by Parliament. In other words, certainly, as I read it as a practitioner, there is a broad consensus among judges about the proper approach to statutory interpretation. It's what Professor Frickey and others have described as a pragmatic eclecticism. It's perhaps unsurprising. It's the same thing that's been noted among many Australian judges. The consensus, I think, involves more than a view that it's best to take a little bit of everything. One thing that I think drives the consensus in Australia is a judicial reluctance to take ideological positions. There's a view, I think, that there are a few things more beguiling and a few things more likely to lead you astray in deciding a case on particular facts than having a theoretical axe to grind. The important point, to my mind, about the result of the cases in the last couple of decades is that the broad consensus is principled as well as pragmatic. The Australian High Court is able, I think, to be principled as well as atheoretical only because of the work being done by the Academy, in particular by Professor Frickey and his peers over the last few decades. That's what's enabled, I think, the judges to be informed by the purposivist critique of textualism, by the textualist critique of purposivism, and by everybody's critique of intentionalism. And so the ultimate thing I want to do with this paper is to acknowledge the debt that I think the legal system owes to the Academy, especially to Professor Frickey and his work. It is very much one of the three arms of the administration of justice. I think while most judges are naturally inclined towards pragmatism rather than propounding grand theories, there are some fields where that can only be done in a principled and reliable way if the theoretical foundations are being debated elsewhere, and I think statutory interpretation is very much one of those areas. And in that regard, I think I may be Pollyanna, but I think things probably have changed from the middle of the 20th century when Hart and Sachs told us that there's no intelligible, generally accepted and consistently applied theory of statutory interpretation. It's true that judges are still pragmatic and atheoretical, but in Australia at least, there's a degree of principle and even predictability to the court's approach to purpose and to legislative history. And that has only arisen, in my view, because of the work of Professor Frickey and others in the Academy.
John Manning.
Thank you, Professor Farber, and I'm very grateful to have been invited to be here. So I'm grateful to Professors Garrett and Farber and to the California Law Review and to Bolt Hall and its staff and faculty for making this possible. When you think about what to write about a career like Phil Frickey's, it's a bit daunting. And so I started out wisely taking many weeks to do this, started out reading his articles. I tried to read one a day, and that takes many weeks to get through the corpus. And as I read through it, what occurred to me was what a profound influence Phil Frickey had on my own career and on the development of the modern debate about statutory interpretation. One of Professor Frickey's great talents is as an intellectual historian. With Bill Eskridge and on his own, he's written a lot about the history of statutory interpretation and the intellectual developments in statutory interpretation in the 20th century. And I thought, what will his contribution be understood to be in the modern revival of statutory interpretation? And as I thought about it, it occurred to me a couple of debts that I owe him, and this will organize my comments. One is what I learned about statutory interpretation, and the other is what I learned about being an academic, because I came into the business late after about a decade in private practice, and I had no idea what it meant to be an academic. And as any person entering public law at the time had to do, I read a lot of Phil Frickey's work, a lot of it on his own, a lot of it with his writing partners, Eskridge and Farber. What two amazing teams those are. And one of the things that I got out of it was that Professor Frickey is great at disagreeing with people. When you have children, you learn that you're not supposed to yell at them because they hear the yelling and not the lesson, right? And it's true of academics also, right? If you are gentle and kind and respectful to those with whom you disagree, they will hear you better, they will understand, they will learn from you better. And there's something about the way that Professor Frickey and his partners write that really conveys that lesson in a big way. And that's something that I, as a young academic, really tried to take to heart the respect and kindness and gentle nature of his disagreement. And so as I thought about the ways in which we disagree, it occurred to me that one big contribution, at least I think it's a contribution, Phil may be horrified, that one big thing that Professor Frickey did in his career was, I think he kind of saved textualism from itself. And I was thinking of calling my paper "How Phil Frickey Saved Textualism," and then I just decided it would be too hard for him to take. So I called it Second Generation Textualism. And so let me explain how I came to this idea. So when I made the transition from being a public law person in practice, in government, and in an appellate firm in D.C. and all that stuff, and so I kind of watched the court very closely. I was in the Solicitor General's office. And one of the big things in Washington in the 1980s was, and the early 1990s, was the assault on legislative history, right? Justice Scalia and Judge Easterbrook took the lead in that, but they had allies in the lower courts like Judge Buckley, Judge Starr, Judge Kaczynski. And the thing about it was that in these early days of textualism, the interesting thing was that textualism was very pragmatic and very empirical, right, in its approach. Textualists had a target. The target was intentionalism. And it was kind of an attractive target because the court, and I think Professor Frickey would agree with this, there were moments where the court was excessive in the way that it used legislative history and in the extent to which it subscribed to the idea that what it was trying to do was discover legislative intent. And so you would see in the court's opinions statements like this, right? The authoritative committee reports, quote, leave no room for doubt about Congress's intent, right? Equating these committee statements with the intent of Congress as a whole, or even, and I will admit that I'm taking this a tiny bit out of context, but it's too good not to read. This is the famous quote from Overton Park in 1971, where the court said, the legislative history is ambiguous. Because of this ambiguous, it is clear that we must look primarily to the statutes themselves to find legislative intent, right? So the culture had gotten to be one where legislative intent loomed very large and where the perception was growing that it was being somewhat manipulated by the court to reach results that the court wanted to get to. And so when Scalia and Easterbrook started writing about this stuff, they felt that they had a rather tempting target. And their view was, let's go after the practice in a sort of pragmatic way. And so what did they say? Well, it's very connected, and this will be how I link this to Professor Farber and Professor Frickey's work. So a lot of what they did, what Scalia and Easterbrook did, was draw either implicitly or explicitly on this burgeoning field of public choice scholarship, right? The idea of economic analysis of political science. And so Scalia's work was very much in the tradition of the interest group theory, a branch of public choice theory, right? What he went after was committee reports are unrepresentative. Right? Why are they unrepresentative? Committee reports are unrepresentative because they're written by staffers at best or at worst by lawyer lobbyists who are slipping into the committee reports things that they could not or didn't want to pay to include in the statutory text. And so committee reports were unrepresentative of the body as a whole. You wouldn't take them to be representative of the median legislator because they were just a way for lobbyists to buy legal norms on the cheap. And he said this again and again. Famous one was in a case called Blanchard versus Bergeron, where this theme comes across most clearly. And so he says, don't pay attention to legislative history. You can't equate it with legislative intent. Easterbrook, Judge Easterbrook, was even more dramatic, right? So his position was there's no such thing as legislative intent. So he's built on the work of Kenneth Arrow, as translated a bit by William Riker, another famous political scientist, who called it chaos theory, right? That was the theory of the legislature, that the legislature is chaos, right? Preferences will cycle, right? If you have multiple legislators with multiple preferences, their preferences will cycle. The way that you stop them from cycling, right? So cycling is legislature might prefer A to B to C and then prefer C to A, and it just keeps going through that loop. How do you stop cycling? Well, the only way you can do it is through arbitrary agenda control, and then there's the possibility of strategic voting and log rolling, and when you put it all together, legislatures have no intent, so stop looking at legislative history and trying to figure out what the intent is. And so there's something about this that's very intuitive and very sort of, primal, a kind of a sense that there were shenanigans going on in the legislative process, or that the legislative process wasn't worth trying to figure out, and therefore judges should stop looking at legislative intent. So in the late 1980s, in a series of articles that culminated in this very important book, which is still available at popular prices. Did I say that right, Dan? Okay. So Law and Public Choice, A Critical Introduction. This book is such an important book. I cannot tell you, I became a professor in 1994. I cannot tell you how many people on and off my faculty told me, this is the book you have to read. Right? This is what, if you're doing legislation, if you're doing administrative law, if you're doing common law, you have to read this book. So I was untenured. I read the book. And here's what the book does. It challenges the empirical assumptions of the first generation of textualists, and it does so really quite magnificently. So these two characters read a mountain of political science scholarship. And I retraced their steps at one point, and let me tell you, this is dense, difficult, often unpleasant stuff to read. It has multi-petaled graphs and three-dimensional graphs, and it talks about yolks, and not the kind of yolks that we have for breakfast, yolks and uncovered sets and multiple equilibria, and it's very, very hard to get through. These folks figured out a lot of interesting things. So one thing is, it turns out that interest groups don't dominate the legislative process in the way that public choice theory had been portraying. So it turns out, if you look at the empirical studies, if you look at all the empirical studies, it turns out that legislators vote on the basis of a very complex set of factors. One thing is, they do want to please the interest groups who give them campaign contributions and support and publicity and all sorts of things like that. But they also care about the public interest. They also care about they also vote in part on the basis of their ideology. It's much more complex than the sort of unidimensional idea that interest groups are buying legislation and therefore buying legislative history on the cheap. More importantly, they studied this chaos theorem, and they discovered that, of course, the idea that legislatures are chaotic and completely unpredictable is not what we observe in practice. And so why is that? Well, here are a couple of observations, right? One is, often you have preferences that are what's called unipeaked, which means that they array across a spectrum left to right. And when preferences are unipeaked, they don't cycle. So that's one way of controlling chaos. Here's another way of controlling chaos. Legislators actually have norms of fairness and reciprocity. So they don't endlessly bicker to try to get the maximum advantage for their own private interests. How else do they control chaos? Well, it turns out that there are all sorts of mechanisms of agenda control, including committee consideration, that set agendas in a predictable way and close off debate. And what Farber and Frickey showed is that this idea of chaos and cycling and unpredictability is just way, way overblown, right? And now, the book is enormously fair, by the way, in the sense that it acknowledges that there's a grain of truth to all of this public choice stuff, but that it's way, way overblown. Okay, so what effect and I almost forgot, there are, besides the political science arbitrage, which is enormously valuable, the sifting and the analysis and the translation is unbelievably valuable. There is such deep insight in this book, and I'll just mention one point because it'll be relevant in a moment. One of the things that Farber and Frickey say is, look, there are all these mechanisms for controlling the chaos of a legislature, all these rules of procedure. And one of the things that we have to understand is that the rules of procedure, democracy is not self-defining, and the rules of procedure by which law is made are part of our democracy, and they have to be understood as part of the process of legislation and the way that we understand the meaning and creation of legislation. And that strikes me as an extremely important and an extremely deep insight. So I read this book and I was hugely depressed because my facile understanding of why I was a textualist was, gone. And it seems to me that the book, so that there were many critiques of public choice theory, many critiques of textualism, but the thing about this book is it was so careful and systematic and fair that it raised the cost of relying on that first generation sort of notion of chaos and interest group confusion, and it forced textualism to re-examine itself. And so there's been a second generation of textualists, of textualism. Partly Scalia himself has changed his tune a little bit. You see much less of this kind of writing. I think Judge Easterbrook has not relied on the same themes quite as much, though I understand he was here making the point about chaos just a couple of days ago, so maybe that point isn't as strong. I'll have to get a copy of that speech. But the textualists changed, and so you now have a lot of different kinds of textualism. You have Jeremy Waldron and his idea of law and disagreement. You have Adrian Vermeule and his use of decision theory and theories of second best. The court itself has shifted from the sort to a kind of a second generation of textualism itself. And here's what I think that is. So here's the piece of textualism that's stuck. It's not the chaos theory stuff. It's not the interest group stuff. It's the idea that legislation is compromise, right? And not in a bad way, right? It's not an ugly kind of compromise, interest groups bargaining, buying legislation. It's that people who have disagreements go to a legislature and they talk them out, and they work them out, and they come to an agreement, and they split the difference. And if you look at the court's cases now, where the court is acting textualist, what it says is, law is compromise. Compromises are not perfect. Compromises are about means as well as ends, and we have to respect both the means and the ends of legislation. And let me say, I think this is a much more attractive version of textualism and a much more sustainable one. And I'll say a couple of words why, and then I'll close. The court has under-theorized why it cares about compromise. So why do we care about compromise? We could care about all sorts of things, coherence, fairness. So compromise has been a big theme in the court's cases. And why is that? So I think this is why, and it links back to Professors Farber and Frickey's point about you have to pay attention to the means of the legislative process. I think that the focus on compromise welds the legislative process to interpretation in an important way, and here's why. Both the constitutional rules for legislation and the rules adopted by each house are calculated to do something which I think is very obvious, right? One thing is they're meant to give political minorities extraordinary power to block change, right? Bicameralism and presentment has been shown by another branch of public choice theory associated with James Buchanan, and it's worked its way into the legal literature in various ways, that bicameralism and presentment approximate a supermajority requirement, right? Gives minorities, political minorities, power to block change. The rules of each house are designed to give outliers and political minorities extraordinary power to slow and block change, right? Rules of unanimous consent in the Senate, the filibuster, just countless ways in which the legislative process gives certain stakeholders the power to say, look, if you want to pass a law, you have to get us on board. And what that does is it gives these political minorities the power to insist upon compromise as the price of their assent to get the legislation through. And I think the court's emphasis on compromise recognizes and reinforces that aspect of our legal culture, of our constitutional culture, of our legislative culture, that it's meant to protect outliers, that it's meant to give opponents of change, a way of slowing the process and of insisting upon compromise. And by enforcing the text as written, I think that what the court does, my view is what the court does is it tries to give effect to those compromises to protect the interests of the stakeholders in the process. So what have Farber and Frickey done then? Well, a couple things. One is, in a funny way, so this is just ironic, I think they made textualism more formalist, right? It's less based on this idea, well, committees they're all dominated by interest groups. In the real world, they're doing something kind of nefarious, right? So it's more formalist, it's more resting on constitutional norms than on facts in the world. But the other thing they did, and I think this is the most important thing, and I think that this is how they made textualism a more attractive and sustainable and gentler philosophy, is they took away its anti-legislative edge. The early writings in textualism had a little bit of a sense of, gosh, these interest groups, they're dominating the process. They're slipping things in. They're pulling the wool over our eyes. Or, look, how can you say you're looking for intent? That legislature, it's chaos. They have no intent. They're just randomly kind of going through with arbitrary outcomes that are dominated by whoever happens to control the agenda or who's ever most intelligently made their strategic votes. It's a very unattractive and I think not sustainable way to relate to the legislature. In a culture like ours, which is rooted so deeply in premises of legislative supremacy. So I think that the early approach, which very much had a kind of eat your spinach approach to the legislature, was not a sustainable way of thinking about the statutory text. And so I think that by getting us off of that approach, Farber and Frickey saved textualism. Thank you very much.
Our next speaker is Peter Strauss, and I'm a little afraid to learn what else we may have saved.
Lights, please. Okay. What you're about to hear is a piece of on-the-road scholarship. So I think it is probably more a kind of repaying of the debt that I owe to Phil Frickey in my own scholarship than it is an exploration of his, hard to find in Ethiopia and Australia, other places where I've been. His commitment to practical legal studies won my admiration early on in his career. And so what I'm going to try to do is a constructive approach to what seems to me an enduring problem with some bearing on his lifelong attention to interpretation. I think you'll probably hear in it something of a pragmatic, lower-level follow-on to the brilliant paper you heard from Robert Post earlier today. And if it won't make the problem go away, maybe it'll help reveal its inevitable tensions, and thus get us past theoretical exegeses that suggest simple answers. How can it be legitimate to permit unelected officials to create binding legal texts? That's the problem. It's a problem for judges as well as regulators, a problem that's heightened by constitutionality review. For judges, we deal with this problem by pretending that they're only involved in interpretation. While the judges themselves frequently write as if they'd made law by their statutory interpretation, at least the text of their decision is not seen as having in and of itself legally binding force for anyone but the parties. For regulations, like statutes, the situation is different. A violation of the Secretary of Agriculture's rules about the grazing of sheep in national forests, unlike violation of the rule in Shelley's case, is in and of itself a basis for sending someone to jail. So to shorten this oral talk, the printed paper will be a good deal longer. I'm going to omit most discussion, how the democracy deficit is seen in parliamentary systems, and use PowerPoint to show you quotes that I won't read to you. The idea of parliamentary responsibility, I might say, essentially merging legislative and executive powers, tends to settle concerns about possible democracy deficits, even if thoughtful inquiry shows that the bureaucrats, and certainly not the parliament, are effectively in charge of most of the statutory instruments, what those folks call regulations, that become law. And it was parliamentary democracy there we go. It was parliamentary democracy that provoked John Locke's forceful rejection of delegating the political authority people had conferred on their elected representatives to unelected persons. The difficulty, of course, as Ed Rubin once showed us, is that in today's complex society, putting the power to make law in other hands is inevitable. There's just too much for elected generalists to accomplish. And besides, while we might want elected politicians to decide, come on, I keep doing the wrong one. No. There we go. This is not behaving as it should. I'm going to do without showing you the quotes rather than struggle with Murphy's Law. They're there, and I just have to ask you to work out what they were. While we might want elected politicians to decide whether and under what procedures to mandate the provision of safe drinking water, we would not trust them, we could not trust them, to decide as a matter of political will just what levels of arsenic make drinking water acceptably safe, 1 part per billion or 2 parts per billion. That requires an act of judgment informed by good science. Legislatures are entitled to have the general sufficiency of their work product assessed as the product of political will. That's why American courts limit constitutional review of economic measures to the barest notions of rationality. But will we say the same about agencies making rules? The very practicalities that require intransitivity in legislation imply, for me at least, that political will alone cannot suffice. And here we encounter the difficulties with the strong unitary view of presidential authority. As one element of his iconic opinion in Marbury versus Madison, Chief Justice Marshall early asserted that the sufficiency of political will, rather than assessed judgment, for those matters committed to the president's discretion was enough. The review of the acts of persons who had to act as if they were uttering the president's decision was not subjectable to judicial review. While it regularly reviews agency decisions, the Supreme Court has found in the commitment of authority to the president a reason to decline review. The president is not an APA agency. And here I'll use a form that I use in teaching the subject, the discretion that Chief Justice Marshall is describing would be found to fit APA Section 701's exclusion of matters committed to agency discretion from any review at all, if it were. But this is hardly the case when it comes to the exercise of discretion in the form of executive agency rulemaking. While the APA in Section 701 excludes any matter from judicial review to the extent it is committed to agency discretion, Section 706, which couldn't be reached if the plain meaning, if the textual meaning of the previous sentence were followed, explicitly provides for review of abuse of discretion. The court has squared this circle by characterizing as the realm of unreviewable discretion settings lacking law to apply, where the law does set standards, as it must, where agencies are authorized to act with the force of law, one finds rather discretion. Here, while courts must not substitute their judgment for the agencies, they nonetheless are to engage in searching but narrow review. That's another quotation from the Overton Park case, for those of you who don't recognize it. For three decades, some have celebrated this development as a means for giving and this is Bill Pedersen writing, "Those who care about well-documented and well-reasoned decision-making, a lever with which to move those who do not." I want to try briefly to connect the dots amongst discretion type, reviewability, and delegation. In practice, the delegation doctrine has had decisive force only if the authority exercised appeared to involve discretion and not discretion. The legitimacy of delegated discretionary authority, that is directly tied to the possibility of judicial review for the rationality of its exercise. For delegated discretion, the judicial review is at 180 degrees from discretion. Legislatures can exercise will rather than judgment. Our votes empower them to, but not agencies. One might think a similar concern implicit in the Supreme Court's repudiation of cost as an element permitted the EPA and Clean Air Act administration. Permitting so wide-ranging a set of decisional factors would have underscored the enormity of the power thus conferred. This consideration seems often to have moved the court in the quasi-delegation context. It's one of those canons of avoidance that we've been hearing about. In Massachusetts versus EPA, the majority rejected an explanation of EPA's refusal to engage in rulemaking about carbon dioxide that was grounded in foreign relations concerns. And I'm sorry not to be able to show you the quote on that one. And in its decision just 4 weeks ago in Energy versus Riverkeepers, the court majority, while finding cost permissible as a consideration in Clean Water Act administration, insisted that this was because Congress had so permitted. The president hadn't made it up. Phil would find in the three energy opinions, I think, fascination for their tension among the usually textualist and willing to look at the end trials justices. Professor Rick Hills immediately questioned, and it seems to me with apparent reason, whether Justice Scalia, writing for the majority, looking neither left nor right at what had happened in Congress, had not abandoned textualism for Chevron deference that he has previously claimed textualists are much less likely to invoke. But what's important to note about the case from my perspective is that all 9 justices asked what Congress had provided. For all 9, the decision was EPA's to make, that is, not the president's. And for all 9, those processes involved the exercise of reviewable judgment, not will. Of course, the tension between technocratic and political views of agency action isn't new, and any thought of rationalizing administration as simply the exercise of expertise has long since vanished. But is it then just politics? Like Phil and like Robert Post, here you begin to see, I hope, the overlap, I refuse to accept that. And if it is rather necessarily an admixture, if we refuse to accept the arbitrariness of just politics, but it is impossible to achieve a government of laws and not of men, stricto sensu, how do we keep the law side in significant operation? Dean Edley was among the first of many to note for us how inevitable and appropriate some intrusion of politics into rulemaking is. Notice, though, how much more problematic dependency on the president's election as a rationale is for us than the practice of parliamentary responsibility is. Cabinet secretaries answer only to the president and White House staff. Our governments never fail. In the parliamentary sense, our election dates are set well into the next millennium, and we never, as such, elect the government. And then there are the influences of what Phil and his casebook colleagues have so persuasively pointed to as veto gates. Simple majorities in both houses and presidential assent suffice to enact or alter statutes, usually to be tested in court just as acts of will. But for rules to which the president has assented, Congress would have to muster supermajorities to overcome the expectable veto of its acts of disapproval. And because instant governmental failure is not in the cards, because whatever the president does, any thought of political retribution has to await a subsequent election in which he will be on the slate only one time in 2, the idea that that will control his actions is remarkably remote. The development of aggressively centralized presidential oversight, even control of executive agency rulemaking, seems to me to give this problem new prominence. Adherents of the strong view of the unitary executive celebrate that trend, finding in the Constitution an essential right of the president to command all executive action. In effect, they regard the EPA administrator as one of those officers who are, and now these are Chief Justice Marshall's words from Marbury again, to conform precisely to the will of the president, the mere organ by whom that will is communicated. They don't seem to notice what Marshall said would follow from this proposition, that those actions could never be challenged in court, or its tensions with the ideas of Section 706, Overton Park, and State Farm. Their point, I suppose, is that the president is elected and that in this way any democracy deficit is cured, but for the reasons I've tried to suggest, that doesn't satisfy. Indeed, given both the privacy screen behind which it is exercised and the extraordinary range of measures that might be subject to it, in my judgment, presidential control makes the democracy deficit not better, but worse. It invites political will to be exercised in a manner undisclosed and essentially uncorrectable. I've written elsewhere at length how such considerations lead me to find in the president's obligation that the laws be faithfully executed a responsibility to accept that Congress has conferred on others duties that they are to exercise, and to exercise not as a matter of will, but as acts of judgment. The courts, that is, have to have a role in relationship to rulemaking, and that role can't be an empty one. And we can find this proposition instinct even in opinions that openly accept the intrusion of political considerations into rulemaking. Thus, the decision in Energy, again, divided 5-4 over whether cost was an acceptable element of EPA decisions under the Clean Water Act, but it was unanimous in framing that decision as being for the EPA, proper if, as the majority reasoned, cost was a permissible factor, and the EPA's reasoning could survive the usual standards of judicial review. And Judge Patricia Wald's canonical decision in Sierra Club versus Kossel is to the same proposition. People who celebrate her recognition of the legitimacy of presidential advice tend not to notice that before getting there, she spent 103 pages in Fed Second closely attending to the EPA's reasoning. Kevin Stack has persuasively explained this outcome in the most fundamental of separation of powers terms, grounded in the long-standing administrative law proposition that agency decisions must be justified in the terms the agency has used. Well, what if agency explanation were to include political considerations, maybe ones impressed upon them by the president? If they weren't factors that Congress had authorized the agency to consider, that is, if interjected just on the president's authority, then Massachusetts versus EPA holds that that reasoning would be unavailable. To reason otherwise would take us straight into the quagmire suggested by Youngstown Sheet and Tube's proposition that the president is not to be a rulemaker, as well as Chenery, Marbury, and the stated dependency of valid delegations on demonstrable legality. My essay will spend some time addressing Dean Kagan's suggestion that congressional acceptance of presidential authority to interject ought to be presumed as a matter of congressional intent. Here I want briefly to call your attention to a couple of very recent contributions to the literature that aren't yet in the law reviews, but have been posted on SSRN that address the problem. The first is by Professor Nina Mendelsohn of Michigan, including political reasons in agency decision-making. And she finds it striking, wouldn't we all agree, that after more than 3 decades of formal presidential oversight of agency rulemaking, openly stressing the importance of analyses and factors that make eminent political sense but are rarely explicit elements of agency mandates, her diligent resource could not unearth a single acknowledgement of its influence in an agency rule. Statements of basis and purpose just don't mention, much less explain, changes that OIRA rule review may have induced. And so Professor Mendelsohn asks, wouldn't we be better served by statements that acknowledge the White House input and resulting changes in ways that permit the continuing rationalizing constraints of judicial review? And then just 3 weeks ago, SSRN carried an abstract of Professor Catherine Watt's article proposing a place for politics in arbitrary and capricious review, and the title tells you that it's cut from the same cloth. Neither of these drafts, at least so far, is as astute as I would hope for it to be about the Marbury-Youngstown delegation side of the tension I've been trying to sketch for you. But what's important about them is not just their realism about the inevitable, indeed appropriate place of politics and agency decision-making, but also their insistence that it be visible and rationalized, that the use of politics, rather than reflecting obedience to one whose will could never be questioned in court, has to be seen in a form that permits explanation and invites review. As Professor Watts put it, arbitrary and capriciousness review should encompass political influences that an agency openly and transparently discloses and relies upon in its rulemaking record. And these issues are significantly in play today. In early directives, President Obama has promised respect for agency responsibility, significant advances in transparency, and a thorough revision of Executive Order 12866, which is the formal mechanism by which the White House interacts with rulemaking. But as his critics have already noticed, the instruments by which he did this contain significant reservations that I can't show you, looking the other way. And in my judgment, a great deal hangs in the balance. Well, to sum up, and you don't need to write the note, Dan, my effort here is not to solve a problem, but to suggest tensions likely to endure and that it is in our best interests to have endured. Our continuing challenge is to recognize the importance of politics, the imperatives, if you like, of the democracy deficit in rulemaking, while at the same time keeping excessive power for covert action, for the concretization of simple will out of any single pair of hands. And in today's world, our risk of failure in this effort lies principally with the presidency. How then can we safeguard the belief that we live in a rule of law culture of constrained, reasonable judgments, even as we recognize the contributions that political will can make? It isn't easy. It's not hard to find oneself peering into the abyss. In another recent article, Adrian Vermeule has reminded us of the bleak assessment of the German philosopher Carl Schmitt. Dan tells me I should refer to him as the Nazi philosopher Carl Schmitt. Schmitt wrote about, and Vermeule is principally concerned with, the problems of law in emergency, but the black holes and the gray holes that he describes, as indeed Vermeule remarks, pervade administrative law's efforts to constrain the irrational exercise of power. We cannot ignore them, but neither must we succumb to their gravitational force. So I want to end, as I began, by invoking Phil's lifelong commitment to practical legal studies. In this most real of all possible worlds, as my friend Roy Schottland put it to me long ago, accommodating reality is the best we can hope for, and Phil, you've given us a treasure house of those efforts.
We have about 10 minutes left before we need to break for lunch. I thought what I would do is first ask for audience questions, and then if nobody steps forward, I will try to fill the gap. But I'd much rather hear your questions.
My question is mainly from Manning and Brudney. I think Phil might even be smarter than Manning gives him credit for. Phil might have lured the textualists into this formalist trap, and then at exactly the same time when he's working on the public choice theory book, he's also doing his Stanford article on practical reasoning, which John does suggest, and so this is a question for you, there are pitfalls in this formalist approach. Because statutes are compromise, you should only look at the text. And Phil's practical reasoning article suggests deep difficulties with that. One difficulty is epistemic, particularly before the 80s, when legislative deals were almost never clearly expressed in the text and much more clearly expressed in the conference committee report. Textualism has the Brudney bait and switch problem. That's epistemic. A second problem is purposive, particularly when circumstances have changed, as they always do, usually because the statute is adopted, then neither the text nor the legislative history is going to clearly address all future problems. And so there the task is trying to understand from the legislature's point of view, so this is a hermeneutic objection, what was their project? And one criticism that Phil makes of the Stanford article of textualism is that in understanding what their project is, the way they used language, their purpose, their expectations, is by immersing yourself in the legislative history. So the difficulty with formalism is that in practice, it might be unworkable and ultimately disrespectful to the legislative process. And isn't that luring a kinder, gentler textualism into another kind of dead end?
No.
Brudney.
Yes.
And there we have it.
So I think you're right. I think there is a certainly transition problem with textualism, right? Because if you think about one of the key tenets of textualism is that textualists are users of language like other users of language, right? And the only reason language is intelligible is because we come from a community in which we have shared practices for communicating with one another, right? The only reason that we understand what we mean when we say, dog is that, there's nothing magical about that word. There's no intrinsic meaning. We've come to have that practice. And if the practice by which legislatures expressed where the deal was by putting it in the legislative history, there is a retroactivity problem in textualism, even if you think that textualism is a wise way of forcing the legislature to put up or shut up, right? To say, look, if you want to have an explanation, right? Legislative history is a text, and statutory text is a text. So you can put the explanations, you can vote on the explanations if you can get them through. So I think it's a reasonable default position, but you're entirely right. There's a transition problem when the expectations were that it would be used to illuminate meaning or reveal what the deal was. Now, in terms of the overall question, is textualism sort of wooden and anti-legislative? I think the answer is no, and here's the reason. I think that Easterbrook's best work is the work that acknowledges that law is about means and ends, and that one part of the things that legislators bargain over is not merely the purposes they seek to achieve, but the price they're willing to pay to achieve those purposes through the means that they've specified for accomplishing them. And I think that when a text is clear, right, so I think that that's what textualism means now. When a text is clear, when its semantic meaning is clear, looking outside it to evidence of what the overall purpose was, or even looking at the statute as a whole to figure out what the overall purpose is, and using it to vary the specific meaning of a particular means of accomplishing that overall purpose, is disregarding the fact that law is about means and ends, and that legislators compromise about both. And that's why I think that the text is a pretty, when it's clear, right, when it's clear, I think it's a pretty reliable way of getting at what the compromise is.
I guess I want to say a few things in response to the question. I mean, one is that I think John's textualism is kinder and gentler than a lot of people on the Supreme Court and the courts of appeals. It's one of the reasons why he has become the most significant and persuasive exponent of textualism. I think he's giving a lot more credit, perhaps, to the judges who are aligned with him in terms of how far they've gone down that same road. I mean, I do a lot of empirical work involving how the court reasons about both workplace cases and tax cases. And it turns out that Justice Scalia, although he will use legislative history and dissents in order to show the majority that he can use them at least as effectively as they can, never, ever uses it in majorities. And I don't think that's necessarily be, and that's over a 35-year period. He's never used it in a single majority. He's written in statutory workplace law or tax law. And other justices use them for very different reasons, whether it's discerning bargains or borrowing expertise, respectively, in workplace law and tax law. So I think there's a subtlety to the way legislative history is developed by the justices and also lower court judges that has not been accessible to at least some textualist judges who take an admissibility rather than a weight position about it. I think a really hard question that John has raised, and maybe is also implicit in Bill's question, is why should we look beyond the text when there has been a bargain or a compromise? I mean, I think I can think of two reasons. One, because the bargain or compromise isn't a politically expedient way to avoid resolving a question, particularly the question that's being interpreted by the court years later. It was a larger bargain or compromise to get a bill enacted that didn't fully address all the different questions that are contained in a word, so that when Congress has a word like in the National Labor Relations Act, you can't coerce, restrain, or interfere with the right to engage in organizing. The dictionary definition of coerce, restrain, or interfere with is not the definitive statement about how what that language means. The definitive statement turns out to be developed over decades of NLRB practice identifying why a captive audience meeting isn't actually coercion, restraint, or interference, why one-on-one discussion between a supervisor and a line employee isn't coercion, restraint, or interference per se, although people would disagree about that. Lawyers disagree about it. Courts disagree about it. It's a very specialized question. It's not limited to the ordinary meaning of language. And so I think to some extent we're talking about ex ante considerations that legislatures have that are different from ex post considerations that courts have. And to some extent we're also talking about the inevitable imprecision of language that sets rules. And in both of those instances, not legislative history is as definitive as text, but legislative history is relevant and can shed light on what people thought they were voting for.
I want to inject, if I can, a brief reference to another of Adrian Vermeule's works about the cycling characteristic of judicial approaches to legislative history. Judges watch Congress, Congress watches judges, and so one has to ask, what is the future, what is the likely future effect of congressional realization that judges will only work from text? And Francis Lieber put it really well 160 years ago or so. I view nothing with such, quoting Robert Peel, an English parliamentarian, I view nothing with such distaste as reading acts of parliament that result from judges taking a libertarian view of legislation. They go on endlessly. Ultimately, one must rely on common sense. I thought I heard John concede, actually, that conference reports submitted to both houses and revealing the deals ought to be regarded as appropriate for understanding the statutes to which they are appended.
I think you misunderstood.
I have to say I suspected that too. It would be, I think it's a pity that we can't continue both of the panels that we've had so far. It seems to me there's obviously enough to talk about for a day or 2 days and instead of the limited period that we have. But it really has been, I think, a remarkable interchange of ideas. One thing I did want to say is that one thing that I think one learns from co-authorship is something of the strength of another person's voice. I think those attributes of reason and fairness and open-mindedness and civility, I wouldn't like to think that they're entirely due to Phil. But I will say that in my case, I think even my independent writing has, I hope, gained in some of those attributes from the experience of working with Phil, both in co-authorship projects and otherwise. And that's a form of scholarly influence that I think is rarely discussed, but still very important. We now, a piece of text, lunch is ready. And so we will reconvene after lunch for a panel which really brings constitutional, legislative, and other considerations together in the context of Indian law. Thank you.